SMS Edwin Tong.
Mr. Deputy Speaker, I thank the members for all their comments, suggestions, and ultimately the unanimous support of the bill. When the Small Claims Tribunal was first conceived of over 20 years ago, its overriding philosophy was to provide a straightforward, quick, and inexpensive way of resolving claims of low value. That remains true to this day, and we must strive to keep to that philosophy. While I'm grateful for suggestions to further enhance the jurisdiction and accessibility of the tribunal, and we've heard many today, we must keep in mind the need to delicately balance what we seek to achieve through the Small Claims Tribunal and what these suggestions might then take the process towards. And whilst many of these suggestions are good ones and take us closer, they do take us closer to what it might be like to appear in court. And we must not forget that at the end of the day, whilst the claims can be brought in the Small Claims Tribunal, with all its limitations that we have heard about, there's nothing to stop a party from going to court with lawyers, as Engineer Lee has suggested, if you wish to, or without the limits, as some other of the members have suggested. So we must bear in mind that at the end of the day, the Small Claims Tribunal sits in the system and ecosystem of a series of options available to a party. And we must bear in mind, at the end of the day, that we are trying to reach a quick, expeditious, and inexpensive resolution. And it is with this philosophy in mind that I addressed the concerns that have been brought up. And I'd like to do so with three broad overarching themes. And these are, first, the coverage and jurisdiction of the tribunal. What does it cover? Second, the accessibility and affordability of the tribunals. And finally, the conduct of the proceedings at the tribunal. Various members have raised the possibility of expanding the jurisdiction of the tribunal. They suggested that the tribunals cover other types of claims, that the claim limits could be increased, and the limitation periods for claims before the tribunals could also be lengthened. I'm heartened to hear of such support for the work of the tribunals being voiced, to the extent that my fellow members here in this House agree or urge that jurisdiction should be further expanded. I would like to assure members that we have been and will continue to periodically review the jurisdictional claims limits of the tribunals and also the types of claims that should come before the tribunals to ensure that they continue to remain relevant given societal changes. In fact, Mr. D'Souza's suggestion, or question rather, as to why hire purchase has now been brought in is precisely one of those points that is now more prevalent and a lot more germane to what parties seek dispute resolution over, and so they are now part of the rubric of the Small Claims Tribunal as well. Mr. Lim and Ms. Rahayu have highlighted the newer types of claims arising from new consumer behavior. I think Mr. Lim mentioned old bikes as well. These claims for unreturned deposits, yes, they do cause a degree of angst, but they are also new types of claims brought about by somewhat new advance in the new economy. And so, whilst the claims do exist and they do need to be resolved, I think it will be necessary to study them and the ecosystem in which they occur to determine the extent to which they are suitable for resolution by the Small Claims Tribunals. Again, I urge all of you to bear in mind that there's nothing to stop these claimants from going to avail themselves of court services. So, nonetheless, we assure members that my ministry will closely monitor these developments, these new areas, and continue to review their suitability for inclusion within the tribunal's coverage at a later stage. Members also suggested taking stronger measures in relation to cases of consumer claims that fall within the jurisdiction of the tribunals. Specifically, Mr. Lim queried if businesses could be prohibited from inserting arbitration clauses in their contracts with consumers which purport to oust the jurisdiction of the tribunals to hear any dispute. In a similar vein, Mr. Saktandi also suggested mandating that all hire purchase contracts include a clause that both parties may approach the tribunals in the event of dispute, in the event a dispute arises within 2 years of entering the contract. Ms. Pereira also suggested introducing a 2-week cooling-off period for all hire purchase contracts. As a general principle, the government adopts a balanced approach to supporting pro-enterprise environment, while at the same time protecting consumers. And I would urge members to bear in mind that we are looking at it in a very balanced way, not just and not only from the viewpoint of the consumer. A too heavy-handed intervention in favor of either party could lead to market distortion or unintended consequences. Hence, we wish to be slow to mandate the use of specific clauses in commercial contracts between private individuals and businesses. Likewise, this is why the government has not introduced cooling-off periods for hire purchase contracts. That is not to say that there is no recourse for unfair terms imposed on consumers today. As Mr. Lim, President of CASE, correctly pointed out, contractual terms which are substantively unfair based on widespread international consensus can still be voided under the Unfair Contract Terms Act. And on that point, Mr. Lim's comment on the use of the Unfair Contract Terms Act, notwithstanding that there is an agreement between parties, if it is shown that it falls within the UCTA, the provisions can still be set aside under the UCTA. Similarly, the CPFTA, or the Consumer Protection Fair Trading Act, also provides consumers with protection against unfair practices, such as pressure selling and false claims. Consumers who have reason to believe that sellers have engaged in such practices may also approach CASE with details of these practices for CASE to assist them in seeking redress. In addition, a key way to protect consumers and ensure they have a level bargaining field when disputing a contract is to improve their awareness of the institutions such as the tribunals through public education. I thank the various members, including Engineer Lee, for raising this point, and I will speak about more of this shortly. Mr. Saktani queried whether a tenant who has entered into a 2-year lease contract with an option to renew may make a claim in the tribunals. That, I think, really depends on the context in which it arises, the specific negotiation of that case, and the extent to which parties have regarded it as an option to renew as opposed to a fresh lease. I'm not saying that it is not covered, but one needs to look at it quite carefully to determine those legal and factual questions. On a separate note, Mr. Chu asked if the ministry could work with the tripartite partners to develop industry-specific mechanisms for freelancers. I think he mentioned the gig economy on this. Steps have already been taken to enhance this area. For example, the tripartite standard on contracting with self-employed persons, a set of guidelines on best practices for engaging freelance services, was launched in March 2018 with the support of the government. We will no doubt convey Mr. Chu's suggestions to allow certain disputes involving freelancers to be mediated by the tripartite partners to MOM. I turn now to accessibility and affordability of the tribunals, which both Ms. Pereira and Ms. Rahayu touched on. It is important to ensure accessibility to the tribunals. There are 3 aspects to it: awareness, user-friendliness, and cost-effectiveness of the tribunals, and I'll deal with all 3. First, state courts have, through various outreach programs, to educate various segments of the public on the tribunals and the key features. CASE has also been referring consumers with eligible claims to the tribunals. This includes elderly consumers who approach CASE. We will look further into the suggestions raised by Ms. Pereira and Ms. Rahayu in this regard, as we continue to work with the state courts to generate greater awareness about the tribunals and improve accessibility. Second, efforts have also been taken to ensure that the tribunals are user-friendly, even for claimants who are less IT savvy and who, as some members have pointed out, are in need of assistance either language-wise or expertise-wise in navigating the judicial process. As a starting point, the State Court provides a complimentary pre-filing online service to all potential claimants. By answering a few general questions, claimants can better ascertain the viability of their intended claims and whether those claims can, in the first place, be filed in the tribunals. This process generates a summary of issues, known as notifications, which informs potential claimants of the requirements they must meet or the documents they must prepare to proceed with their claim. This ensures at a very early stage that proceedings before the tribunals progress smoothly. Parties will come prepared with the necessary evidence and the documentation to support their case. Parties may then file their claims on the electronic filing system, or CJTS. On that CJTS platform, parties may engage in e-negotiation and e-settlement, as I mentioned at the outset, or 2, schedule hearing dates and times in an electronic diary if the settlement is not reached. C, view their case details and correspondence with the court. Or D, submit documents, or E, make payment. Several members suggested that CJTS could be supported by a hotline or call center, and that special arrangements be made for those who are visually impaired or illiterate. I thank these members for the opportunity to clarify that indeed these avenues are already in place to help members of the public who may not be comfortable navigating the CJTS on their own. One option is for them to call the tribunals at a number that is listed at the website or available on the brochures if they have any queries on the tribunal's process or services. This hotline provides a multilingual service for users who may not speak English. Another option is for them to go in person to the tribunals, where there are student representatives and trained officers from the state courts who can guide them through the filing process in their own mother tongue. During the hearing itself, court staff and interpreters are also on hand to provide assistance during proceedings. Parties who are visually impaired or illiterate may, in those cases, be represented by a third party who may sit in with them and assist them in the course of the hearing. In relation to the CJTS, Mr. Patrick Tay expressed some concern that an average layperson would find some of the pre-filing questions challenging to answer. He suggested simplifying the language or providing a glossary for court users' easy reference. Those are good suggestions. However, as mentioned before, there are trained state court officers and also student representatives from local law schools who are on hand to assist the users. They assist to answer questions, explain the process of the tribunals, and manually guide them through the process of filing a claim. That said, we have noted the feedback on how it can be further improved, and we will certainly look into it with the state courts as part of our efforts to continuously enhance accessibility of court services. Mr. Tay also asked if the list of notifications on the points that one should take note of before filing a claim using CJTS may intimidate or otherwise deter some claimants from filing their claims. Our experience, in fact, so far has been to the contrary, as some claimants have commented that the pre-filing assessment and list of notifications in fact help them better understand the jurisdiction of the tribunals and see in advance the potential issues of their case so that they are better prepared. Associate Professor Fatima Latif queried how frequently the e-negotiation system on CJTS has been used. Between 10th July 2017 and 15 June 2018, e-negotiation has been used by parties in 755 cases. In about one-third of those cases, parties reach a settlement online. These are encouraging early indicators. Third, on the affordability of tribunals, allow me to assure Associate Professor Fatima Latif that the tribunal's cost structure is specifically designed to be affordable to the wider public. Let me just illustrate that with some of the numbers. When filing a claim, a party is required to only pay a lodgement fee. Today, lodgement fee for consumer claims range from $10 for claims up to $5,000 in value, or up to $200 for the maximum limit of a $20,000 claim. It's otherwise 1% of the claim amount. For non-consumer claims, the lodgement fee ranges from $50 for claims up to $5,000, or to $600 for claims up to $20,000, or 3% of the amount in question. Further, in some cases, the successful parties may also apply to recover their fees or disbursements or a portion of it from the losing party. Mr. Louis Ng mentioned that in a previous PQ that the cost was in the range of $400 to $600 for a $2,000 limit. Even in that situation, even before these amendments, the limit was already $10,000 for SCT jurisdictional limits. In most cases, parties must appear in person, a point that Engineer Lee raised. That itself reduces the need to pay legal fees. Parties, however, who require legal assistance at the hearing may also approach the Community Justice Center at the state courts for free on-site legal advice. So free on-site legal advice is provided at the state courts for any user of the SCT who wishes to avail himself or herself of legal advice. And we must also bear in mind, taking into account Engineer Lee's suggestions, that the model that we are trying to build for the SCT is really one that is inexpensive, fuss-free as far as possible, and quick. And sometimes the introduction of lawyers into this mix doesn't quite provide for all of those. It may be a little bit less inexpensive, and it may just take a little bit longer. And so we are trying to find the right balance, and the SCT amendments try to deal with that proposition. Members have asked about the amendments to allow costs to be ordered at the discretion of the tribunals. Let me say a few words about this. Today, costs can only be imposed in a very narrow situation where a claim is frivolous or vexatious. This has limited the tribunal's ability to manage litigants who conduct their cases in an abusive manner. Thus, the amendments allow the tribunals to order costs at their discretion. The intention is for such cost orders to be made only in the most egregious of cases, where a party has been unusually disruptive, uncooperative, or contemptuous, even if the claim itself cannot be said to be frivolous. So it's really directed at the conduct of the proceedings. And one bears in mind that with the amendments that we have in place, there are 3 stages to the proceedings, as I mentioned at the outset. And the process can, in fact, be unreasonably stretched out by an unreasonable litigant. And the discretion for costs is designed to give redress to that. Several members have asked how we can ensure that the practice of awarding costs under the new provision will not discourage litigants with bona fide claims from bringing their claims before the tribunals for fear of, and I quote Mr. D'Souza, getting hit with a cost order. Mr. Murali-Pillay also raised this point, and I think these are very valid concerns. I would like to assure members that since legal representation is not allowed in the tribunals, save for the very narrow band of persons, the cost for litigants will be kept low. Costs will be calculated according to the general rules according to governing costs for litigants in person. For example, a litigant in person will be reasonably compensated for the time he has expended, for example, taking leave to attend a hearing and other such related costs, in addition to expenses reasonably incurred, for example, transport costs. So one can see that the paradigm is very different from where one seeks party and party costs in a situation where lawyers are involved. And I hope this addresses the members' concerns. In light of these guiding principles and our court's own experience and expertise in quantifying cost orders, and also as Mr. Ng pointed out, Order 59 of the Rules of Court already set out the parameters on which cost orders ought to be granted, we do not at present see the need to limit the amount of costs that can be ordered against either party in the tribunals. But members should be assured that they will be judiciously considered each time. Finally, I turn to the comments and suggestions which members raised in relation to proceedings in the tribunals. As I mentioned at the outset, the guiding principle which underpins these amendments is to facilitate an efficient, effective, and inexpensive avenue for the resolution of small claims. The tribunal magistrates play a key role in ensuring that the tribunals meet the desired goals. To achieve this, the state courts ensure that all the tribunal magistrates are not only legally qualified, but also experienced in hearing cases involving members of the public. Tribunal magistrates, referred to as referees today, also typically render brief oral grounds after each case, setting out the reasons for their decision clearly. They also address queries and clarifications which parties may have at that juncture, and this is to ensure that all parties, as far as possible, are aware of and can understand the reasons for the decision. Mr. Dennis Tan raised a question about whether or not the state courts would have sufficient training for these magistrates. Rest assured that the courts regularly, in fact it's been in the past, it will continue to be the case, conducts training and continuing education for its judicial officers, and that would include the tribunal magistrates. I note Mr. Lim's feedback that some users of the tribunals, however, are not fully aware of the reasons as to why their cases did not succeed. We will continue to work with the state courts to look into how this can be improved, to ensure that the work of the tribunal magistrates in terms of how they have come up with their decision and the views of the case can be properly and best conveyed to the users of the SCT. Mediation at the tribunals, something that Engineer Lee brought up, and I agree with her that as far as possible we would like the cases to be mediated, which is why it's now designed to be two-staged. At one stage it happens outset online, and if that doesn't happen, the parties can then be asked to attend mediation. And that, as far as we're concerned, is the best outcome in a case. Even if there's a dispute, one should not rule out an amicable settlement, even at a late stage. I've mentioned earlier that the proposed amendments to empower the registrar of the tribunals to order parties to attend mediation at the Community Mediation Center or before any other person. Mediation facilitates the just, expeditious and economical resolution of cases. So therefore, tribunals will, where possible, encourage parties to strongly consider mediation. Some members have raised a concern about uncooperative parties using mediation as a tool or an excuse to drag out the case, and asked whether penalties will be imposed on deliberately uncooperative parties, and generally raised that point. The majority of parties generally approaching mediation has been done in good faith, and they do so hoping to resolve their differences amicably. Some do it because they wish to see an end to the dispute. Others do it because there's a continuing relationship with the party against whom a claim is being made, and they wish to preserve that relationship. So for a variety of reasons, we have seen the parties come forward still in good faith to undertake mediation. Mediators are also trained to help facilitate constructive discussion between parties, whilst court counsellors also provide counselling services to users at the same time. If, however, a party is wholly unreasonable in refusing to mediate, is unusually disruptive, or is very uncooperative, or takes a very unreasonably disruptive stance during mediation, then the tribunals can and should take this into account when deciding on costs at the end of the day. It's difficult to legislate upfront what can or cannot be done in a mediation, because mediation, by its own definition, is really got to be dynamic. It's got to respond to the parties' needs. It's got to respond to how the parties each see their position and see their case. So I don't think it can be legislated upfront as to what should happen, but rest assured that the conduct of the parties and the way in which it is going will be taken into account by these facilitators, the mediators, and ultimately the tribunal magistrates. Mr. Lewison queried the parties to be provided with information on ADR processes to guide them on whether to go for ADR. Such information is currently already available through pamphlets and guides at the state courts, and certainly it is a big part of the suite of services offered at the state courts. So state courts is not just about the litigation or the dispute resolution process by going to court. ADR is very much a part of it. In addition, parties can also approach state court staff or the Community Justice Center at the state courts if they have any further queries or require any guidance on ADR. On case management powers, several members have spoken about such powers of the tribunal, in particular the power to consolidate claims, order costs on parties, and so on, and I'll address them as follows. On the question of consolidation, Mr. Pillay raised the question of whether the higher limit for the aggregate value of the consolidated claims can be brought in the tribunals. I can see where Mr. Pillay is coming from, but this again is really a question of striking the right balance. If we allow allowing claims involving a common question of fact or law to be jointly heard and decided in the tribunals can reap the rewards of efficiency and also consistency, as Mr. Pillay pointed out. But on the other hand, allowing too many of such claims with high aggregate values to be heard in the tribunals may well be unfair to the respondent. It may well become a very high-stakes issue for the respondent and significantly increases his potential liability, without at the same time affording him the corresponding benefit of stricter procedural and evidentiary rules, and also of the prospect of being represented by a legal counsel. It was also looked at, this question, by the High Court in Freely against Ong Kai Lee, a 2010 decision, where the court commented that the tribunals are not the most appropriate forum for dealing with a large number of consolidated claims involving multiple parties. And the simple process of the tribunals was really designed for a single complainant to bring a small claim, which is relatively straightforward and not legally complicated, for it to be resolved inexpensively and expeditiously. Nonetheless, we will continue to monitor the need or demand for such actions, and also consider Mr. Pillay's suggestion of an intermediate solution of stipulating a higher monetary limit for the aggregate value of consolidated or representative claims in our next review. Ms. Tana and Mr. Chu also queried whether class action suits in relation to bicycle sharing arrangements and microtransactions can be heard in the tribunals. This will, of course, depend on the ceiling limit, the aggregate value ceiling limit of the claims in the actions. The tribunals can hear such claims so long as the aggregate value of the claims does not exceed the tribunal's claim limit. Ms. Pereira asked how claimants can establish their claims in the tribunals where documentary evidence is not available. Again, this is one of those occasions where we need to strike a balance and also bear in mind that there is a need to, whilst allowing the claimant to bring his case, but also ensuring fairness and justice being done to the respondent, who has to face this claim. Generally, documentary evidence would usually be the best and most probative type of evidence. However, it is not the only evidence which a tribunal, including the SCT, can consider. The tribunals will also look at, for instance, evidence as to whether the seller, for example, had made an oral representation and what those terms of the oral representation might be, whether or not the goods that were sold were objectively of a satisfactory and acceptable state or otherwise. So there will be other non-documentary and non-written types of evidence available. Relatedly, Ms. Pereira asked whether where the tenant breaches the tenancy contract, the landlord may recover stamp duty paid as damages. That also depends on the facts of the case. For example, the nature of the contract and the provisions that are in the contract itself. But I would not, by simply looking at the face of the SCT rules, rule it out on that score alone. Next, I'd like to touch on some points on appeals which various members have spoke about. Ms. Rahayu asked if...
Order. Doesn't look likely that you'll end before 7. So consequently, pursuant to Standing Order number 2, bracket 5D, I propose to extend the time of this day's sitting beyond the moment of interruption for a period of up to 30 minutes. Please proceed.
Thank you, Deputy Speaker. Ms. Rahayu asked if it would be useful to give litigants in person more time beyond 14 days to seek legal advice to prepare the notice of appeal. It is important to remember that the 14-day deadline is only for parties to file the notice for leave to appeal. At this stage, the appellant need only set out the points of appeal briefly. If the district court gives leave to appeal, the appellant then has 1 month from that date to file his notice of appeal. And the notice of appeal is in a prescribed form, which is contained in the SCT rules, which only requires the appellant to state the grounds of his appeal in brief. It is only when the appellant files his petition of appeal 21 days after serving the notice of appeal that he is then required to set out in greater detail the particulars of the matters in regard to which the tribunals are alleged to have erred. The appellant only has to make fuller submissions on his appeal at the day of the hearing before the district courts. I hope this reassures Ms. Rahayu that an appellant will have ample time to seek legal advice on the appeal if necessary. On Clause 16, Mr. Pillay asked whether allowing a case to be reheard on a ground involving issues of fact is in fact consistent with the previous approach of narrowing the scope of an appeal from tribunals to the High Court. Clause 16 empowers the District Court to direct cases to be remitted back to the tribunals for reconsideration or rehearing by a different constituted tribunal only in limited cases, such as where new facts become available and it is manifestly unjust to allow the original decision to stand. In such cases, even though leave to appeal to the High Court has not been granted, as it does not concern an issue of law or jurisdiction, it is nonetheless important to ensure that parties are provided with an appropriate and right recourse through the reconsideration and rehearing by tribunals. This, I would add, is also consistent with the practice in tribunals in other jurisdictions, such as those in Hong Kong and New Zealand. On a related note, Mr. Pillay asked if empowering the District Court in this manner effectively gives the DC supervisory jurisdiction over the tribunals. That is not the intention nor the desired effect of this clause. The DC's power to remit cases for reconsideration or order a rehearing does not fall within the definition of supervisory jurisdiction, and this was explained by the Court of Appeal in a case City Wall Safety Glass against Man Source Interior, and if Mr. Pillay wants the citation, it is 2015 1 SLR 797. In particular, the District Court which remits a case or orders a rehearing is not reviewing the proceedings and decisions of the tribunal below. It is merely directing that new evidence which was not previously considered be considered by the tribunals. I now turn to the enforcement of tribunals' decisions, on which a few members spoke about. While the State Court does not currently track statistics on the success rates of enforcing tribunals' decisions, I fully agree with Mr. Tay and Mr. Chu that the enforcement process must be simplified and accessible to court users. The tribunals have made steps in this direction. When an order is made, the tribunal magistrates will brief the claimant and respondent on 1, the consequences of non-compliance, with the hope that in doing so, the respondent will be more aware of the consequences of not obeying the order in favor of the claimant. 2, the options which the claimant has to enforce his order. So right at the outset, the claimant is aware of the suite of options that he has available. 3, provide information which the claimant may consider in deciding whether it is worthwhile to commence enforcement proceedings or not. 4, the typical enforcement fees that he might incur. So all this is given upfront and told to the parties at the stage where the order is made. The tribunal magistrates will also give parties a brochure at the end of the hearing and address any questions that the parties may have about the judgment. Members of the public may also approach tribunal staff in person or through the tribunal's hotline if they have any queries on the enforcement process. Mr. Ng and Mr. Chu asked if there are plans to relook the costs involved in enforcing a money order issued by the tribunals to make it more cost-efficient for the average claimant to enforce his order. I thank Mr. Ng and Mr. Chu for the suggestions. Indeed, the Ministry of Law is currently reviewing the process of enforcing civil judgments and orders, and this includes orders by the small claims tribunals as well, with the aim of making enforcement more affordable and, as far as possible, more effective. We will also study Mr. Ng's suggestion to carve out separate enforcement process for low-value claims. I would add also, in relation to the proceedings, a suggestion brought up by Mr. Dennis Tan, that today any individual, whether a party or a non-party to the SCT proceedings, can ask for and obtain a copy of the judgment to find out what has happened and what was ruled and how it was ruled in each particular case. On vacant possession, Mr. Pillay raised some concerns about the enforcement of a specific type of order which the tribunals can make, namely the power to order delivery of vacant possession in claims for unpaid rent. This was on the basis that not even the Magistrates' Courts has jurisdiction to hear and try such action where there is no claim for a sum of money. And I think he's referring to Section 52(1)(a) of the State Courts Act. Mr. Pillay asked if there will be safeguards when the tribunals make this order. Insofar as Mr. Pillay is concerned with that the tribunals are being given power to make an unduly onerous remedy, I would like to set out the following points in response. First, tribunals have been hearing tenancy claims involving unpaid rent for some time now, since 2005, and they have developed the relevant expertise to deal with this type of claims. Vacant possession is a usual remedy for unpaid rent. It's one of those follow-on consequences. If rent is not paid, particularly when it is not paid persistently, then it is only right that the landlord has an option for getting vacant possession back from the tenant. So it's related to unpaid rent. And empowering the tribunals to order the delivery of vacant possession where necessary broadens, in my view, fairly the suite of orders available to ensure that justice is done. Second, while it is correct that magistrates' courts do not currently have the power to hear claims which are exclusively non-monetary in nature, they do have the power to hear claims for unpaid rent and make orders of vacant possession. The amendments merely extend the same power to the tribunals for claims of lower value. And I've noted Mr. Pillay's point on mezzanine profits and double rent as well. And all of that is really subject to the overarching jurisdictional limit. So no more than 20,000 for rent, mezzanine profits or double rent. Third, to ensure safeguards, the state courts will also be instituting internal guidelines which will set out the factors for the tribunals to consider before making an order for delivery of vacant possession. That further enhances and strengthens and prevents any risk of such orders being made erroneously. Finally, I wish to touch on the workload of the tribunals, a point that that Dennis Tan also raised. The various amendments and expansion of the jurisdiction are likely to lead to an increased workload, and that ultimately is the overall policy objective of these amendments. Associate Professor Fatima Latif asked about the average number of cases handled by the tribunals annually and what the common types of cases were. From 2015 to 2017, the tribunals handled an average of more than 10,000 cases annually. The common types of cases are disputes over contracts for sale of goods and provision of services, followed by claims arising from damage to property and leases of residential premises. While the caseload of tribunals is likely to increase after the expansion of jurisdiction, I wish to assure members that tribunals are prepared to deal with the increased workload, and they will also, on their own, regularly review the resources to ensure that the tribunals remain an efficient and effective avenue for the resolution of small claims. Mr. Tan also asked what is the anticipated growth in the number of cases. Just as a ballpark indicator, the number of cases filed in the state courts where the claim was between 10,000 the current limit, and 30,000, the new limit with consent, is about 9,000. So there are about 9,000 cases which fall into that category. But bear in mind that this range includes from 20 to 30,000 cases which can only be brought to the SCT with consent. And there are also, on top of that, subject matter limitations in terms of the kinds of cases that can be brought. So we don't expect that 9,000 to surface in the Small Claims Tribunal. There will be a portion of those, and certainly that is the reason for these amendments, to drive more of the cases to the Small Claims Tribunals as far as possible. In conclusion, I wish to thank all members who have spoken and supported this bill. Refining the tribunals to improve their processes and enhance access to justice requires an ongoing long-term effort. The many helpful suggestions and thoughtful comments by each of the members who have spoken today contributes to this worthy endeavour. Mr. Speaker, sir, I beg to move.
The question is that the bill be now read a second time. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Small Claims Tribunals Amendment Bill.
Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 23 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. SMS Edwin Tong.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Small Claims Tribunals Amendment Bill.
Leader.
Mr. Speaker, sir, I beg to move that Parliament do now adjourn to 12 noon tomorrow.
The question is that Parliament do now adjourn to 12 noon tomorrow. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Order. Order.